For a lot of us, the question you want to ask yourself is, what happens when the work dries up? Or what happens when the contract ends? How can we effectively use redundancies in a way that's good for us and for the team that we have working for us? So we have the man who knows all about this, Mr. Phil Eberhard. He is the Senior Workplace Relations Advisor with Master Plumbers. He provides an invaluable service to members when it comes to time to renegotiating union and non-union enterprise agreements, and also provides advice on a range of employment workplace relation issues, including difficult staff, termination of employment and managing entitlements. But today he's going to be talking to us about the high-level issues associated with redundancy and redundancy payments. Ladies and gentlemen, please give a Master Plumbers welcome, Phil Eberhard.
Thank you. Can I just quickly say one thing? Sean spoke about notice of termination and provisions in letters of offer. For a significant number of you, if you employ plumbers, you may well employ them on what they call a daily hire basis. So a plumber under the award or under a number of agreements can be employed in that style. In that situation, they only require 1 day's notice. So it's a very building industry specific type of provision. So a daily hire employee would get 1 day's notice. A weekly hire employee would get 1 week's notice or additional notice in regards to that. Now, I'm talking about something completely different in that particular sense. I'm talking about the redundancy provisions that exist for both plumbers and also potentially your other employees, so your admin employees in that sort of situation. They can be found in either the Plumbing and Fire Sprinklers Award or an enterprise agreement, and in regards to the non-plumbing employees, they can be found in the National Employment Standards. Now, the one thing that we should say in regards to redundancy is that redundancy is a separate entitlement to notice of termination, and notice of termination provisions need to be paid out at the same time as redundancy pay needs to be paid out. So, where an employee, so for a plumber or a fire sprinkler fitter under the award or under the union agreement, where an employee ceases to be employed by an employer other than for reasons of misconduct or refusal of duty is the definition of redundancy. So it's important to note that the words other than have a great impact in this situation, because the reality becomes is that if an employee resigns their employment, so if a plumber resigns their employment, they are entitled to redundancy pay because they have resigned because they haven't been terminated for reasons of misconduct or refusal of duty. So it's a different situation in regards to that for plumbers than it is compared to an admin employee or myself. If I tender my resignation from Master Plumbers, I'm required to give the requisite period of notice, but I don't get any additional payment. I don't get a redundancy pay in that particular situation. But a plumber is entitled to redundancy pay. Now, if they're covered by the union agreement, the reality would be is that the employer has more than likely been paying into Incolink, and the funds in Incolink would satisfy the redundancy pay obligation. But if you are an employer that is covered by the Plumbing and Fire Sprinklers Award, you are obligated to pay redundancy even though the employee has resigned their employment in that particular situation. So it's a very, very particular definition of redundancy, and it's a very, very significant provision because it is completely different to the vast majority of employees in that particular circumstance. By a way of an aside, we have made application through the process through the Fair Work Commission to try and vary this particular provision in the award. That will be dealt with hopefully at some stage during the year, but at this stage it is only an application, so you need to be aware that you need to follow through in that particular sense, and you need to pay redundancy if an employee resigns their employment. So in regards to the National Employment Standards, if the employee's employment is terminated at the employer's initiative because the employer, I should say, no longer requires the job done by the employee to be done by anyone, except where this is due to the ordinary and customary turnover of labour or because of the insolvency or bankruptcy of the employer. Now, in this particular situation, as an example, let's say you're a widget manufacturer who makes 10,000 widgets per day and has 10 employees who make 1,000 widgets every day. I come in as a salesperson and I say to you, I can still get you your 10,000 widgets per day, but I would sell you 5 new machines that would make 2,000 widgets per day. You could then make a decision and say, well, that would mean that I could actually make 5 of my employees redundant because the job that they have been doing is no longer to be done by anyone. You would still be making 10,000 widgets in a day, but you'd be making it with 5 employees rather than 10. So in that situation, redundancy occurs for people who are non-plumbers in that particular circumstance. So their job has disappeared and it's no longer to be done by anyone. What that doesn't mean, though, is that it can't be spread out amongst other classifications, other employees. So, for example, let's say if you decided to make redundant your receptionist and you required other employees to answer the phone. That's fine because the role can be transferred amongst other employees. It doesn't mean that the role just completely disappears and no one answers the phone in your business. Your business wouldn't last for too long. You'd probably be making everyone else redundant if you did that sort of circumstance anyway. So, in regards to the NES, the other thing that we should notice is that there are various particular exclusions from payments, and one of the major exclusions under the NES is a small business employer exclusion. And under the Act, it means an employer that at a particular time employs fewer than 15 employees at that time. So all employees employed by the employer at that time are to be counted, and a casual employee is not to be counted unless at that time he or she has been employed by the employer on a regular and systematic basis. So if you are covered by the NES and you have 14 or less employees, then the redundancy provisions in that particular circumstance wouldn't apply to you. But if you have 15 or more, then it would. But this is what I've talked about there, the small business exemption only applies to the National Employment Standards. It doesn't apply under the Plumbing and Fire Sprinklers Award. So if an employee is made redundant, the employer is obliged to pay notice of termination, so we've spoken about that, redundancy pay, outstanding or unused annual leave, and outstanding unused long service leave where that's applicable. So I put where that's applicable because in 2 instances, if you're a plumber, the plumbing company should be contributing to co-invest, and co-invest is the portable long service leave scheme. But if you were someone other than a plumber, the employer is required to follow the provisions within the Long Service Leave Act. Now, they actually only commence on a pro rata basis after 7 years of employment. So once you have 7 years, the employer is obliged to pay you as an employee on a pro rata basis. But if you're redundant and you finish your employment as a clerical and admin employee after 5 years, then you're not entitled to long service leave in that particular sense. So with respect to payments, the amount of redundancy pay payable will depend upon the employee's period of service. To confuse you even further, under the award, service as an apprentice will only be counted if the employee completes an apprenticeship and remains in employment with that employer for a further 12 months. So if the employee is an apprentice and you have made that apprentice redundant, they are only entitled to be paid the redundancy pay in the award if they and have all of their service counted if they have been with you for 12 months as a tradesperson. So I don't want to read all of the entitlements out, but there are attached to the information that Sean was talking about in your show bag with respect to the letters of offer. There is a table that explains the various payments that are required to be made. Under the Plumbing and Fire Sprinklers Award or the union agreement, the highest amount of pay that you have to pay is 8 weeks' pay. That's for 4 years or more service. In regards to the National Employment Standards, so in regards to your clerical and admin employees, I'll read these out and then I'll explain what happens in that particular situation. If the employee has been with you for at least 9 years but less than 10 years, they get 16 weeks pay, so that's the highest payment. If they've been with you for at least 10 years, they get 12 weeks pay. Now the difference is that when the Commission made that decision a number of years ago, long service leave was prorated after 10 years rather than 7 years as it is now. So they discounted the benefit that the employee gets after 10 years because they felt that 4-week difference was made up through the long service leave payments. So I spoke before about Incolink, but redundancy may be offset against any payment that the employee receives from a redundancy fund, so that's e.g. Incolink, and redundancy fund payments can be used by the employer to offset some or all of the benefits payable to the employee by the employer. I think I might have said the same thing in retrospect, in the same sentence in that particular sense. So now, for an admin employee, the NES provides an employer with the ability to vary the amount of redundancy pay payable to an employee. In that particular situation, application needs to be made to the Fair Work Commission, and based upon the information provided to the Fair Work Commission may determine to vary the amount of redundancy pay payable. Now, I say why that's available for the NES. It's not available under the Plumbing and Fire Sprinklers Award because the provisions within the Plumbing and Fire Sprinklers Award are called an industry-specific redundancy scheme, and they are specifically excluded from the operation of the NES, in particular the operation of the notice of termination and the redundancy pay provisions. So there has been a decision of the Commission that has said that whilst this employer may have had a legitimate right to seek to have the amount of pay reduced, they can't actually do it because they are excluded from the operation of the National Employment Standards. Whilst we talk about this particular provision here only applies to non-plumbing employees in that particular circumstance. Now, if an employee leaves during the notice period, an employee who has been notified that their position is to be made redundant may terminate their employment during the notice period. If an employee does such, then they would be entitled to be paid the redundancy pay they were entitled to, but would not receive the remaining period of notice. So if you had someone who'd been with you and you'd given them 4 weeks notice, and after 2 weeks they say, well, I've got another job and I want to leave immediately, they are entitled to do that, and they would still be paid their redundancy pay, but they wouldn't get the remaining period of notice that they get. So in that particular scenario, they wouldn't get the additional 2 weeks. I get a number of phone calls that ask me, how do I go about a process? What do I do? What happens in regards to redundancy and the discussion? There are obligations in the award, in the agreement, and it doesn't matter who you are or where you are in this particular sense, to consult. Now, consult doesn't mean that there is a requirement that you get the agreement of the employees, but you have to give the employees the opportunity of actually trying to influence the decision maker. So you don't walk in and say, this is what's going to happen. You walk in and you say, we think that this is what's going to happen, this is what we are proposing. If you have any alternatives or any suggestions, we are happy to consider, we are happy to look at them, we are happy to think about them. What I always say to people is I say, do what I call the 5 W's. So what's happening? Why is it happening? When's it happening? Who's it happening to? How's it happening? And I always say how has a W in it, so that's where the 5th W comes into. Thanks, Elaine. I always trust you to laugh, but no one else. So the one thing is, in this particular regard, seek advice, seek assistance, because it is an important thing. But the most important thing about all of this, I think, at the end of the day, is that for a plumber, even though the plumber resigns, the plumber is considered to be redundant, and the plumber is entitled to get redundancy pay. Now, you may all sort of sit there and go, that's a very strange concept, it's a very strange idea. Rightly or wrongly, that is what the award says. Right? And as I said, we are seeking to change that. Whether we are successful is a completely different matter, but the reality is that's what exists, and that's what you need to be aware of. Completely different circumstances for your other employees. Warwick did say at the start that we were going to have a question and answer session. We're not doing that any longer, so if you have any questions about anything, whether it be redundancy or anything else, I'm happy to take them. If not, thank you for listening.
Phil, is there a period where the employer that's actually giving resignation can actually come back to the employer after a set period of time? if he realises he gets the Sophie's listing today, if they be done it, and he says, oh shit, I resigned from a company 12 months ago, I can make a claim.
If you're talking about bringing an application to the Fair Work Commission,
I'm just talking about a claim of the employer that's his resignation.
okay, I'll answer it in two ways. If there's an application for, say, unfair dismissal or adverse action that's made, it must be made within 21 days of the date of termination. So if it's not, then the employer has the right to seek to have the matter thrown out for want of jurisdiction. In regards to if any employee feels that they have been underpaid or not paid a certain entitlement, an employee has 6 years. So today's the 23rd of February. So what were you doing on the 24th of February 2011, and what are you doing on the 22nd of February 2023? Because today, that's what you talk about. So even though if an employee thinks that they've been, for whatever reason, underpaid or unpaid an entitlement, that they have that 6-year window to bring that. And so they could bring an application on the 20th of February 2023 against you for making them redundant today when they say that they didn't get a redundancy package or something like that.
If they've resigned, as you said very clear on that, that's a lot of people very recommended. So if the employers resign on their own will, they're still entitled to redundancy.
Under the Plumbing and Fire Sprinklers Board, and also under the union agreement. Yep. If a plumber resigns their employment because they are being terminated for reasons other than misconduct or refusal of duty, then yes, yeah. So if they've resigned, their employment is ceasing for reasons other than misconduct or refusal of duty, they are still entitled to redundancy, because when you go back to the definition, that's what the definition provides.
And you've got 6 years, so that clause has been in.
That clause has been in since the I'm trying to remember. Yeah, it's been in for as long as most of us have been around in the industry. And can I say that's why we're talking about it? Because Scott, it's exactly what you said just before. Because the reality is that for a significant number of companies, the unfortunate circumstance is that they have that sword hanging over them for 6 years. That they may not have paid it, but they were obliged to pay it. And an employee, once they find that out, can come back against them and say, hey, guess what, you owed me. And if someone's there for 4 years or more, it's 8 weeks' pay. It's not an insignificant amount of money. Well, I'm trying not. Yeah. I'm trying not to open Pandora's box. I'm trying to advise our members as to what they need to do. So it's more than simply a resignation is in effect a redundancy situation under the award. So for a lot of our smaller guys, when I tell them that there is starts with S, finishes with T, and there's 2 letters in between. And yeah, there's a "you are kidding" sort of moment. But the reality is that, rightly or wrongly, that is the situation, and that is the circumstance. So I advise them of that. Whether they follow through with that, I don't know. But that's what my job is, to advise them of that, and so we do that in that particular sense. Yes.
Some examples on misconduct and refusal of duty.
So misconduct. Okay, let's say. Well, misconduct is so broad, but misconduct could be anything from, you've been late for work, you're late for work, you've been warned. No, look, I'll answer it in this way. The better, if you're going to terminate someone's employment for misconduct, what the Act requires you to do is in effect notify the employee of the reason why they are being disciplined, give them an opportunity to improve their performance, and then to potentially act on it. So let's say if someone was late for work today, you could sit them down and say, hey, Phil, not good enough, you need to be at work at whatever. If Phil's late again tomorrow, you could say, hey, we spoke yesterday, you were late again today. If Phil's late again the next day, you could say, hey, we spoke for the last 2 days about you being late, still unacceptable. And at some stage in that discussion, you would probably say, hey, listen, you'll be subject to further disciplinary action, which could include the termination of your employment. And if Phil's late again, then you would say, hey, we've spoken on da-da-da-da-da-da. I've warned you, guess what, that's it. Thanks very much, you're now being terminated. Well, if they resign as a plumber, they're entitled to redundancy. As anyone else, it's a resignation. And I suppose the simple answer is, you hope that they don't know what the redundancy provisions in the award actually provide for in that particular circumstance.
By anybody?
I don't know whether it's been tested in the Commission, because the Commission, it's not necessarily a Commission provision because it's an enforcement provision, so it would really go through the courts. But there was a decision not that long ago from the Fair Work Commission in Queensland where a Queensland plumber applied to have the redundancy pay provision provided in the award varied. And varied to nil, I think it was. But what the Commission found was, because it's this industry-specific redundancy scheme, they can't bring the application because the NES provisions that provide that sort of provision for everyone else, bar plumbers, doesn't exist for plumbers. But if you were to do it, you wouldn't take it through the Commission, you'd have to take it through the courts, because, as I said, it's an enforcement provision.
I've got a quick question for you, Phil. We were talking about misconduct before. How do you draw the line between you're late, we give you 3 warnings and a written warning or whatever you need to do, versus it's gross misconduct, you've stolen from us, or that you can just terminate them straight away?
Okay,
is that in the employment contract, or? No,
there's a definition in the regulations, of the Fair Work regulations, as to what's serious misconduct. Now, the fundamentals of serious misconduct basically are that the employee, through their actions, is demonstrating that they no longer wish to be employed by the employer. So they're drunk, they've been stealing, they've committed other fraudulent activity, they've fighting. Those sorts of things that demonstrate that you no longer wish to be employed by the employer in that particular circumstance. Now, when you say you can't terminate immediately, right? Unless you actually saw someone going in and sort of taking the money out of your wallet. You can't do anything unless you raise a set of allegations against them, because it's a process. Now, the other thing that you should be aware of is that, in regards to serious misconduct versus misconduct, is that the Commission has made various decisions about serious misconduct versus misconduct where someone has not actioned the misconduct, in inverted commas, for a week or so. It's then only become misconduct, because it's no longer serious, because you as the employer haven't thought it necessary to deal with it virtually immediately. So if you hear of someone doing something, fighting or theft or anything like that, you've got to start it virtually immediately. You've got to put into place a process that will ultimately see that person disciplined virtually immediately, because if you don't, there's an argument to say that it's only misconduct because you've sort of gone, that'll be all right, I'll just let it go for a couple of days. And if you do that, let it go for a couple of days, it's misconduct, it's not serious misconduct. And the difference between the two is really whether you pay notice or whether you don't. Sorry, yep?
If someone's on probation, does that change things?
If you're on probation, provided that there are two different provisions that you can apply for under the Fair Work provisions: unfair dismissal, harsh, unjust, unreasonable, or adverse action. In effect, that's an illegal termination. So let's say you terminated me because I was female, I was over 50, I was this, I was that, all the discriminatory things, right? That then if you discriminate against someone, they have what they call an adverse action claim against you. That can be made even before you start employment. right? So if and we were talking about this yesterday with Alex and Cam. So if you terminate someone's employment because the example we were using yesterday was if you thought Alex was a bloke, because Alex could be either female or a male name, and Alex turned up and he's a she, and you say, oh, geez, you look of childbearing age. What are you going to do with the kids? What are you going to do if you get pregnant? What are you going to do? All of those are discriminatory things. Got nothing to do with employment, right? Then at the end of the day, they can bring what's called an adverse action application against you. But if you terminate someone in the probationary period for being late, for lack of capacity, or working not working at the right level, as long as you give them the necessary notice period, they can't bring an application for unfair dismissal because they don't have jurisdiction to do so. No. In the probationary period, if you're going to terminate someone, you would give them, you would tell them that this is what you're doing. You would say that I'm terminating you because it's just not working out, because you're not working to the required standard, or you're not doing this. If they're daily hire, it's 1 day's notice. If they're weekly hire, it's 1 week's notice. Yep. You go back to the definition that this is... No.
Where an employee ceases to be employed.
Yeah, you've got to read the words other than, though. So other than turns it round in the sense of it says other than in those cases. So where an employee ceases to be employed by an employer, full stop. Right, so that's what redundancy means. Other than for reasons of misconduct or refusal of duty. So that's your exclusion. And that's in both the award and the agreement in that particular definition. That is the traditional view of what redundancy is, in the sense that is the definition that the majority of people would be aware of what is redundancy, in the sense that the job that is being done by someone is no longer to be done by anyone, right? What I'm saying, though, is that in this particular circumstance, that's the definition that applies in the award, and you need to be aware of it because it's a live and actual situation, and it's a provision that applies, and that's why we're talking about it, because... Troy, that's fine, but what I'm saying is that when you read that's certainly the situation that I provide advice, and that's how I read it, because that when you read the other provisions and the discussions that have been around it, that's what the complaint is. The complaint of all the employer associations that are affected by this, and this is something that applies fundamentally within the building industry, is that the employee can resign and is still paid redundancy. So it's not just me saying this, it's a whole range of, it's the master builders, it's the HIA, etc., etc.
We've got another question over here.
Phil, just a quick one that always comes up. I've just had a work-related injury, come back to work, got my clearance. What about termination?
You can get up and answer your own question. In regards to work cover, there's an obligation to keep the position open for 12 months. If at the end of that 12-month period the employee cannot fulfil what they call the inherent requirements of the job, so let's say that the plumber has done their back, they can't lift more than 5 kgs, they can't squat, they can't bend, they can't twist, they can't turn, all the things that a plumber is meant to do, you may then initiate a process whereby ultimately the employee would be terminated because they can't fulfil, as I said, the inherent requirements of the job. And what that means is that they can't do everything that a plumber needs to do. So it's not something that just happens automatically. but it is a process that you need to go through.
And just quickly, Phil, what about the other one where I've just, it's maybe 3 weeks off work and a bit shitty about the fact they've had an injury and all the rest of it, and I want to terminate him? Can I do that?
Yeah. Can I answer that in a cynical way and say, yeah, you do that and your company will close? Because that's an adverse action type of provision. Because what's happening is potentially you're going to deny the employee a workplace right, which is the right to work cover. If you get an employee who has a work cover claim, you've got to welcome them back into the fold, as the work cover ads show. You know, you should bring a cake out, and you should do everything else that they do in those particular ads. So you should do all of that, but you shouldn't act on them in the sense of looking to terminate their employment. The only time that you should act on anyone in regards to that is where they've been off for more than 12 months. And the reality is that they're not going to be able to return to their pre-injury duties.
All right, I'm going to call it there. Ladies and gentlemen, Phil Eberhard.